Mr. Afam Osigwe SAN will be joining us virtually. I also call on Mr. Patrick Osu, a partner in the law firm. His resume is there for you to see. Patrick is, I want to say Patrick is a good friend of SL. Please, you're welcome. And finally, he needs no introduction. I'm sure all of us have been part of all his various training sessions. Many of us have practically decided to do take up other areas of practice of law because of the efforts this man has made in training. My dear brother and friend, Mr. Tobenda Erejukwe. A warm round of applause for Tobenda, please. So this session essentially looks at the rules of the Nigerian Bar Association, body of benchers, reinforcing ethical ideals, and ethical behaviors, enforcement of guarantee of such behaviors, and what expected ethical behaviors of legal practitioners and judicial officers in Nigeria should be. I'll now yield to the moderator to commence the session. Tutoy, thank you.
Thank you very much, my distinguished Leonard Silk. We're family, and he is one senior lawyer that I respect a lot. Thank you very much, sir. It is my privilege, an honor to be the moderator for this session. I'll just start by saying that the session that went before us has already laid the foundation. We all know what ethics and standards are and what is required of practitioners. So to borrow from the biblical injunction that says, Paul did what? What did he do? I want to see how many Christians we have here. Paul has watered, right? Apollos did what? Paul has planted. Apollos watered, right? And God is going to give us the increase. So I believe that the planting has been done by session 1, and session 2 is going to water on that. And there'll be so much we're going to discuss here today. It's going to be an interactive session. For us, it's going to be different. We want to delve into the real issues that affect us as lawyers. What are the provisions we already have in terms of policy? MBA, what is the role of the MBA? What is the role of the Legal Practitioners Disciplinary Committee? What is the extent of the work that they're doing currently, and what still needs to be done? We're going to be looking at practical aspects. As lawyers, we have duties as clearly stated in the rules of professional conduct. We have duties to the court, we have duties to our colleagues, and duties to our clients that we serve on a daily basis. And it's upon this backdrop that we have carefully curated this panel. As you can see, we have on the panel a distinguished judge of the High Court of Rivers State. She'll be here to give us our own views, practical views about how she sees the issue of unethical conduct, practically in her courtroom every single day. And I believe that it's something that we will all learn from and adjust even in the course of our professional work. We'll also be hearing from a very seasoned legal practitioner. I'm pleased to have on my panel a partner in the law firm that I work in. Ajumagobi and Okeke, Mr. Patrick Osu. He will be giving us a revelation, that's what I call it, of his experiences in over 20 years of legal practice in Nigeria. What has he seen? What does he think needs to be done for there to be reinforcement of ethical conduct in Nigeria among legal practitioners? So I'm looking forward to Mr. Osu's very erudite views on this issue. And then we have one of my speakers on the panel who will be joining us virtually, Mazi Afam Osigwe, Leonard Silk, who would be talking about the policies, just as I said, MBA, Legal Practitioners Disciplinary Committee, what it is that, his views are about the policies and what needs to be done. And then I come back to the room where we have one of my very senior friends and mentor, Mr. Tobena Erojikwe. He'll be here to take us on a journey to what obtains in other jurisdictions and lessons that we can learn from those jurisdictions. So I want to say to you, distinguished audience, you're in for a very good time on this panel. So I want to encourage you to please pay attention as we dive right into what we have today. Thank you very much. So I'd like for us to take on Mazi Afam Osigwe SAN, who is going to be joining us virtually. I believe he's online right now. IT, can you help us put him on? Thank you very much. Leonard Silk, can you hear us? We'd like for you to come up first. Well, these are the issues with technology, I believe. Sometimes things may not really go as planned. So I may have to come back to the room to save our time if he's not able to come up.
I am up and I can hear you.
Okay, but we can't see you on the screen, sir.
No, but I can see you and my video is off. So I don't know what may be a problem from your own end.
Okay, Mr. IT, okay. Okay, fantastic. I think you're up now, Venezia.
Now, the points I'm making is that the LPDC is saddled with the responsibility of disciplining lawyers or legal practitioners who may have breached the rules of professional conduct while acting in a professional respect. Now, this is very important because you may, if you read one of the rules of professional conduct for legal practitioners 2023, which provides that the lawyer shall uphold the rule of law, promote and foster the cause of justice, maintain a high standard of professional conduct, and not engage in any conduct which is unbecoming of a legal practitioner. We must check it that the power of the LPDC to discipline a lawyer is a lawyer is subject to the discipline of the LPDC and for any action of it. Now I say this bearing in mind that Section 11 of our LPA is backward looking. It is not in sync with modern realities. In other clients, once you are a lawyer and you are seen to have failed to uphold and observe the rule of law or promote and foster the cause of justice, or that you have failed to maintain a high standard of professional conduct, conducted yourself in a manner of becoming of a legal practitioner, you are liable to be disciplined. It doesn't matter whether you were driving under the influence of alcohol, whether you beat your wife, or whether you did some other thing in the public or in the community. Now, on the body of benchers, I must note, as a body per se, is not involved in the discipline of the lawyer, but its committee called the LPDC. And I'm glad that Mr. Epuasom has in his presentation highlighted the fact that having a centralized disciplinary process does not work. It takes forever. It makes discipline of lawyers very difficult. I must also highlight another part of the problem, which is the Legal Practitioner Disciplinary Committee Rules 2020 has written MBA out of the disciplinary process. Whatever reason may have led to that amendment needs to be given a second look. Now, if you look at Section 11(2)(e) of the Rules of Professional Conduct of the LPA, Legal Practitioners Act, that section, in my opinion, presupposes that the investigation and the decision to present a charge against a legal practitioner shall be by the MPA. But under the current rules, that power has been transferred to the LPDC. So the same persons who will sit as judge before the LPDC are the same persons who will first of all make an initial prima facie finding and decide that there is need to against the lawyer. Now, what this has done is that because this body sits on an ad hoc basis, it has hindered the discipline of lawyers. So the same body would have to make out time to assess the petitions before deciding to send it to a respondent for his petition, for his response. And then you have soon a backlog of cases, and then it is not helped by the fact that every legal practitioner in Nigeria who is accused of having committed a professional misconduct must come before the body in Abuja. So there is a case for the not for the setting up of many bodies, but for the decentralization of it, or to allow that body to be considered in such a manner as to sit in various panels and the regions. If we can start with the regions, if not the states at the moment. And also the present provision in the rule that insists that it is the complainant that will be of the official complainant before the committee, and that he too must present a lawyer, also imposes a burden on would-be complainants or existing complainants who must instruct a lawyer who, if he's not resident in Abuja or his environment, must come to Abuja to present their case. And we need to also know what happens when such a matter goes on appeal. Will they also have to be the ones paying for legal representation at the Supreme Court? And to my mind, this is a different part of the public who may not have the wherewithal to go against a lawyer from having their matters prosecuted, so to ensure that justice is done in a case. Now, the body of benchers does not make the rules per se. It is Chief Justice of Nigeria that make the rules for the disciplinary committee. And the rules are, like I said, MBA has in the previous years made presentations that there is need for MBA to resume its role of investigating and recommending persons for trial before the LPDC, and that there is need for the MBA to be given powers again to prosecute, to constitute a panel to prosecute lawyers or respondents before the LPDC. Discipline is very important. If we do not take it seriously, or if the process of disciplining lawyers takes such an intolerable length of time before the LPDC, we will lose the confidence of the public. Many petitioners are worried that even when they have complied with the current rules and have written a petition, sometimes it takes a minimum of 2 years before the respondent is asked to respond. And I think that any disciplinary process we have should be optionalized, should be insulated from any form of professional or political interference of man no man, as we say in Nigeria, so that the process must not only be fast, but be such as to ensure that there is confidence in the ability of the profession to regulate its members. Do I think that the profession is overregulated? I don't think so. I don't think we're overregulated. I think that while there may be too many bodies, the regulation is not even as strict as it should be. Many lawyers get away with things that lawyers in other places cannot get away with. You see senior advocates dressed in their robes, addressing journalists, as has been pointed out earlier, and nothing happens to them. And we see them on television and nobody takes them up. In some other clime, nobody needs to present it. The regulatory body will ask you to explain your conduct. And we do so many things that do not make for discipline in the profession, that do not build confidence in the profession, that reduces the legal profession in some cases to an anyhow profession. And so, like I said, at the moment, MBA plays no role any longer unless the 2020 Legal Practitioner LPDC rules is amended to bring back the power of the bar to investigate and to prosecute persons before the LPDC. And I also say, and I insist, that I strongly believe that the power of the bar to investigate and prosecute is protected by Section 11(2)(e) of the Legal Practitioners Act, and that the framers of the 2020 rules were wrong to have written MBA out of the rules. But we are part of the same profession, and we can have a sit down and find a possible way out of it. I am not unmindful of the misgivings that at some point in recent times, the disciplinary process in NBA became bogged down. Petitions were not receiving due attention, and some presidents failed or refused to set up disciplinary panels to investigate allegations, thereby giving the impression that either NBA was trying to protect some persons or that NBA was jettisoning its role of investigating and prosecuting persons before the LPDC. There may have been some other allegations I may not be aware of, but there's every need for all stakeholders to work, for us to have a rule that works, and for us to amend our laws such that a lawyer need not act in a professional respect in order to be disciplined. That a lawyer should be disciplined if his action has brought amounts to infamous conduct or has brought shame to the legal profession, or that the person has not acted in the manner expected of a legal practitioner. I mean, how can a lawyer beat his wife or fight in public and we say we cannot discipline him because he was not acting in a professional respect? Our laws are antiquated, and there is need for us to bring them up to speed. Unfortunately, we lost the opportunity of the amendment of the rules of professional conduct in 2023, not to have amended so many provisions. I have been a prosecutor before the LPDC, and as General Secretary of the NBA, I did a lot of work in sending cases before the LPDC. You will discover that in a number of cases, many infractions, allegations of infractions against legal practitioners cannot be pigeonholed within specific provisions in the RPC. So, more often than not, persons are charged for violating Rule 1 of the RPC. So, we must amend our rules to bring it up to date and in sync with modern realities and provide for certain situations we may not have envisaged in 2007 when the main body of the 2023 rules was enacted. 2023 rules only included money laundering requirements and record keeping requirements and all that we need to do with respect to money laundering, but did not touch on the rules per se guiding professional conduct. So there is need for us to further look at these rules, amend it to bring it in sync with the law, amend the LPDC 2020 to give NBA role to play in it, and also to avoid a situation where those who will judge you are the one who make a prima facie case that you have the case to answer. And I think that may show a mindset of bias and may make their decision liable to challenge, because without hearing one side, you have decided that the respondent has a case to answer. And I think that the determination of whether a person has a case to answer should be done by a person, a body other than the LPDC. The current situation where they was investigating and making a prima facie finding, in my case, amounts to being judge, investigator, and prosecutor. And I think we need to look at it. And we should also allow independent bodies to do this work, and also allow the NBA, like I said, to play a role in it, so that we must show the public that we are serious about disciplining our area members, and that NBA is committed, that the body of ventures is committed, that indeed the entire legal framework for regulation in the legal profession is interested in maintaining the higher standards. In some states, in some countries, it is their courts that are in charge of discipline. I don't know what will work for us, but it's something we should have a conversation on. I agree that the current system does not work. The current system cannot engender conflict in the public, and must do everything possible to ensure that the right amendments are made, and that we must make a law that addresses every given situation and meets the needs of modern day legal practice. Thank you so very much.
Thank you very much. Thank you very much, distinguished Leonard Silk. You have done justice to your question, sir. We're most grateful. A lot of points to take away. He talked about the ad hoc nature of the LPDC, the fact that it's important that we decentralize, and that's a view that I share with Leonard Silk. I believe that the disciplinary body should be brought to the regions, closer to where the users, are. And then for access as well, it's easier to access the LPDC when that is done. And he also talked about reviewing the RPC, which is so important, so that it is brought in line with our current realities. That's the only way that we can feel the impact of the policies that we have. Thank you very much, Leonard Silk. I'll be moving on very quickly to our next speaker. I'd like to call on Mr. Patrick Osu. Sir, I work with you. I know that you have several years of experience in litigation and even in the corporate field. You have seen different sides to unethical conduct among legal practitioners. So this question put to you is to discuss your personal experience in legal practice, the challenges plaguing the enforcement of ideal ethical standards. What are the challenges that are plaguing the enforcement of ideal ethical standards and behaviors in the legal profession? I'd like for you to start with that, and then we'll come back to it later.
Okay, distinguished ladies and gentlemen, my lords, Mr. Chairperson, and my colleagues. I think the panels that we had before essentially set the tone for the discussions we're having today. I'm asked now to talk about my personal experiences. They are varied and they are many, I must tell you. It's really uncountable, to be honest. We have had a situation where I think we should worry more about, do lawyers really understand, first of all, what their role is? I would like to just start by saying that when we talk about ethics, ethics is intrinsic in the profession that we practice. What predates in the pre-20th century was that it was intrinsic that you will be conducting yourself in a gentlemanly manner just because you were a lawyer. So if you said something, your word should be your bond. You were not likely to be second guessed because you had said this. So if I said to you, if I was standing in courtroom and I said to the court, I said, my lord, I'm speaking from the bar and this is what I'm saying. What you have said should carry weight and it should mean something. I mean, in the early days when we started, like I say, I'm not too old at the bar, but I've been there. Where you see practitioners come before the court, the courtroom is not a jest place. It's a place for serious business, because I tell people that if you're a legal practitioner, consider yourself a surgeon. So what you do every day is that you have people in the operating theater, so your skill determines whether they live or they die. And I'm sure nobody wants to be accredited with having to be responsible for the death of a lot of people. And so this transcends into the way we conduct ourselves. So if we're doing things as legal practitioners, which we think that is going to be inimical to the service that we propose to render for our clients, then we should take a step back. But I see that a lot of those things have been eroded. There are situations where we talked about disciplinary committees, we've talked about regulation. I don't think that we're over-regulated. I just probably think that enforcement of those regulations are the problem. So you have cases where, in my opinion, you have certain calibers of lawyers who have infracted the law but cannot be disciplined because of who they are. And so it's a problem, and it's a consistent problem, until we, by ourselves, make the conscious decision to say that we are going to put our foot down, follow the law as it is. We are not going to make much progress. It will continue to be the same circumlocutus situation where we have lawyers who are taking steps that they shouldn't be taking, and then there's no consequences for those actions. In any society where you don't have any consequences, of course, you're sure to have chaos. And so that's where we find ourselves. I've seen situations where a judge of the Lagos State High Court has specifically demanded that Chief Williams be brought to his court for conduct that he considered was contemptuous of the court. Now, I'm not sure that we would have those kind of situations happen now. I mean, if you knew who Chief Williams was, it didn't matter that he was Chief Williams. Justice Kessington insisted that Chief Williams must be brought to his court because, in his opinion, he had conducted himself in a certain manner which he considered contemptuous of the court at the time. Now, that's the kind of thing that we're talking about. If we do not find ourselves in situations where those who we leave to be in custody of the law, those who we consider as primary enforcers, for example, the judges, will not put their foot down when they have to, then lawyers will come to court and do what they like. Justice Olewale sat here and said, he gave us examples of the things that he had done before. A judge is in control and command of his courtroom, his or her courtroom. It is the way you set the tone, that's the way the lawyers appear before you. There are some judges, you know, that come hell or high water, they will be at their courtroom at 9 a.m. And it doesn't matter what you're doing. If you're not prepared, please do not come. So I say that it is generally the way we put ourselves out. Nigerians are generally, because I mean, we've discussed this before, Nigerians are generally people who are conformists, but we don't understand that they're actually conformists. The point is that they must test your will anyway. It is what you put out that they follow. So when you have courtrooms where people who are meant to enforce, I have cases where I've gone to the court and a judge, a lawyer, is doing all sorts of unethical things. And unfortunately, the judge is not going to come down because he's not the lawyer. But I believe that having control of your courtroom determines whether people can conduct themselves before you ethically or otherwise. So that's one side of it. Enforcement continues to be the core thing. If we do not put down the parameters for enforcing this unethical conduct, we're not likely to have any pattern of growth. There were incidences where we've seen a situation where I've been involved in, where a law firm had written directly to our client and had requested to take over matters that we were doing, even though that matter was already concluded. They were oblivious of the fact that that had concluded. That matter generated so much furor within the legal community at the time. But the question is, what then happened? What then happened? So until we really direct ourselves to say that we intend to ensure, like Chukwuka has said, Nikwazomi has said here, if we do not take positive steps, in another 10, 15 years, we will not recognize the profession that we have. So there's so much. It's actually hydra-headed. It's multi in different facets. And we cannot begin to say that it's only one side of it. We worry about regulation or worry about only enforcement. It's a lot of things. There's orientation. There's orientation to deal with it. We have to continue the advocacy, because that's the only way we can understand that, especially young lawyers. Some people have never seen, don't understand what kind of ethic that you call, or how to conduct themselves, even in courtroom. And it's only those who are custodians of this ethics, as I call them custodians, people who have been in the forefront, people who have seen ethical conduct, people who have exhibit ethical conduct consistently, are the only people who can, put this forward and ensure that lawyers are made to conduct themselves properly. So, in my experience, like I said, there's a lot of experience that I have in these situations. We can't begin to pick out each and every one to begin to discuss them. But I think at the end of the day, what we're saying is that ethics lies at the bottom of what we do. Integrity and honesty for a lawyer is key. If a lawyer cannot be honest, does not have integrity, and it's difficult for him to be able to practice law, because that's the core of the ethos, of the ethics of what we profess. So if we are not able to ensure that that is what we do, then it's going to be a long ride. Thank you.
Thank you very much, Mr. Su. Please put your hands together for a well-articulated submission by Mr. Su there. I hear you've made a lot of germane points. You touched on the fact that ethics goes to the root of who we are as lawyers and what we do in our profession as legal practitioners. You've also touched on a very critical point, which I actually subscribe to, when you say that a judge should be in charge of his court, and that's what determines how the lawyers would conduct themselves as well. That is so key. And on that note, I'd like to celebrate the fact that we do have a judge here with us who would speak to the issue that has just been raised by Mr. Su. And I believe that this is one judge that doesn't take unethical conduct lightly in her court. I'm pleased to turn to my Lord, Honorable Justice Lenia Mbo, to tell us how I'm able to deal with what the rules of professional conduct provides for as lawyers in our profession, and how in your position as a judge of the High Court of Rivers State, how you've been able to handle cases of unethical conduct by lawyers who appear before you in your courtroom, where you are in charge of proceedings, and you want to ensure that proceedings are done properly according to procedure, laid down procedure. You're not a judge that is interested in time wasters, on serious lawyers. How do you handle unethical conduct, my lord? Thank you very much. Yes, please, my lord.
Thank you. Good afternoon, everyone. Permits me to stand on the well-established protocol, but allow me to be a little bit biased in recognizing and especially greeting chair of the session, and if you know, Mrs. Umar Alabi, the firm I practiced for 10 years before my graduation. Yes, I was the head of dispute resolution in Primera Africa 10 years before my graduation. So you can see that I'm just a product of that firm, and also from the firm of QC Odita, Professor Fidelis Odita, where I started my practice. So that's the business. I'm going to just go straight to the practical aspects of this question. Practical aspects. A lot have been said about the theory, the laws, the policy, but we know what we see on daily basis before us as judges. I focus on the duty will be adhered to by lawyers, serious-minded lawyers. To understand you will not just come and disrespect the courts, except for ignorance. You shouldn't if you're trained. So most times, yes, to a large extent, comply with, except on few occasions. And when you see that, you have to deal with it immediately. But the one that worries me is especially Rule 34, communication with the judge. Communication with the judge. I see a lawyer pick your phone and you call, my name is so and so, have a matter before you. Excuse me. Say that again. I want to talk about that matter before you. Are you a lawyer? Are you seriously a lawyer to do that? We need to talk to ourselves. Or when they cannot call you directly, they will know someone who knows you, that knows someone who knows you, that knows someone who knows your uncle, grandma. You know, you just get this unnecessary interference, just wanting to just only favor to themselves. It's not allowed. When I get those calls, I'll just tell them, yes, you want to speak about what? A matter before me. Fantastic, hold on. You're being recorded, you can speak now. And the story will change. No, I just wanted to know how you. I said, never you want to know how I'm fine. But this is, it shouldn't be heard of. It shouldn't be heard of. It shouldn't be heard of. And when they come to family members, I tell them, if it's your first time, I pardon your innocent mistake. Try it again. Out of complaint. So, lawyers, you're the one making judges believe like aliens. We can no longer associate. We can no longer have free communication with loved ones because of fear of how you present it and interpret it, your relationship with us, and how you can use that to influence your cases. It's pathetic. It's really, really pathetic. The next duty I want to talk about is that to clients, your duty to clients. And this is in two folds. Your duty to clients, we see one aspect that a lawyer will just generally carry on their head. And that is the duty to represent their clients. Talking about Rule 14 and 15. Let me start from Rule 15. Talks about representation of clients, but there is Rule 1 of that Rule 15 says that in representing your client, a lawyer may refuse to aid or participate in a conduct that he believes to be unlawful, and goes on and on. State all of those conducts. But this is the one that lawyers are very good in adhering to. Doing the client's bidding, dirty, good, bad, and ugly. They are ready to do the client's bidding, including dirty ones. And I credit rule 15.1 made absolute. And so in my course, what I have done, when the garnishing proceeding comes before me, and I see that is a lawyer or the law firm deposing to that affidavit to show cause, and at the end of the day, it is discovered that you have misrepresented facts or you've done anything to aid that bank to conceal information, I will slam costs against that lawyer personally. Personal costs against that lawyer. So in my course, we know that when representing any bank in garnishing proceedings, they will just tell the bankers, depose to the affidavit yourself, I don't want trouble. Yes, because if you aid them do any of those things, you should be held responsible. Enough of, us just talking and talking and talking and not really, taking actions. Let us all take actions in the way that we can. So that's what I do in my court. If you do anything that is unethical, of course it's directly against you. So like my lord said in the morning, why should you come late to court? He said, so when you were talking about 9 o'clock court, were you referring to that? I think so. I believe that this duty to your client, the most important, the one you should carry on your head, and the one you should seek to enforce to the latter is Rule 14, which says that you must be diligent in conducting devotion and dedication in conducting your client's case. And what does that mean? It means in prosecuting the matter, in drafting your pleadings, in presenting your case, being in court on time, doing all that you're required to do according to the rules and procedures of the court. But sadly, this is the one that we see most lawyers fail to do. This is the one that they fail to do. They prefer the other side. But this one that should be legally pursued to the end is the one that we see them fail to do. Because in the era of front loading now, you may not lose your case in your office by drafting your processes. So whatever you have not pleaded, evidence that you have not presented, or facts that you have not, brought out to the purview to the court, there's nothing that can be done about it. It baffles me when I see even cases that sometimes there are no defense on the other side, and then you lose that case. How? How? Because of this lack of diligence in prosecuting your client's case. And in cases like that, I don't know how I feel about it, but I make strong comments about the conduct of the lawyer in handling that case. And I'll read one to you. I had a case before me, so I can read it. Judgment concluded. It's PHC 1842 CS 2019. Judgment has been delivered, so you can go and search for it. This is my comment about the lawyer. Quote, I must state that counsel must be very careful when handling cases for their clients. Clients do not know the law or rules of court. Thus, they cannot assess or inspect the veracity of what their lawyers do. They blindly trust their lawyers and their cases, believing that they will employ their skills and expertise in areas of law, in handling those cases. What learned counsel to the claimant, I've stated his name here, did is a breach of Rule 8 or inspect the veracity of what their lawyers do. They blindly trust their lawyers and their cases, believing that they will employ their skills and expertise in areas of law, in handling those cases. What learned counsel to the claimant, I've stated his name here, did is a breach of Rule 18 of the Rules of Professional Conduct 2023, which demands lawyers' utmost devotion and dedication to the case of their clients. I say no more, end of quote. So if this is one of the cases counsel intended to add to his volume for application for silk, he has to think twice. But as Leonard Ikwazu said earlier, if these comments are not regarded, I don't know whether I'm wasting time commenting on the character and observation I have of the council who have handled the case. So it's really important that these cases should be quality and not quantity. I support that wholeheartedly. The last duty is duty to colleagues from council. Duty covered by Rule 26 to 29 of the Paroles. And honestly speaking, on a daily basis, we see total lack of candor, respect, consciousness among many members of the bar. Just share of boxing match, shouting down at each other. And then you're just put under unnecessary pressure, controlling them when they ought to know the law. And it's pathetic more when it's senior lawyers doing it. And when they go on that way, I just ask one question. Then senior counsel, what are you teaching the younger ones? That's just my question. What exactly are you teaching the younger ones? It shouldn't be. We need to do better. I mean, there's these cases, and I tell them these cases come and they go. But you as lawyers will throw all your emotions into it. In fact, my lord, I'm very angry as what he said now. You have no right to be that angry. You don't have me have any right to be angry. Your work here is to be professional. That's all. Professional. Present your case and leave the decision for the judge. That's all you have to do. I'm not showing, especially when your client is in court, that you are superior to the other, or that you're more powerful than the other. No, it's not. It doesn't sit well, and it's completely against ethics that we all belong to. So, I think with that, I believe that I've provoked your thoughts to some extent, so that we can all examine our attitude, our conduct towards the courts, towards our clients, and towards our fellow colleagues. We'll take more.
Thank you very much, my lord. I told you, didn't I? My lord actually confirmed my earlier statement. And this, for me, is something that gladdens my heart, that indeed we do have judges who are ready to take the bull by the horn, ready to do what is required to ensure that the ethics of this profession is upheld, that our ethics will be reinforced, that the actions taken would serve as a deterrent to lawyers. You heard what she said. When it comes to garnishing proceedings in Port Harcourt now, I'm happy to hear that the lawyers know. You can do it elsewhere, but in my Lord's court, be ready for the consequences if you act unethical. And I want to say thank you very much, my Lord. It takes a lot of courage to do this. And I know that you would keep doing all that you need to do to help our profession. Thank you very much once more, my Lord. Please put your hands together for my Lord. That was really very interesting. Thank you, my Lord. And now, I'll be moving to Mr. Erojikwe. You have heard all that has been said by your co-panelists there. And to talk about what my Lord alluded to when she said the duty of a lawyer to his client. There was an interesting case that was reported recently that in one of the law reports, Nigerian Weekly Law Reports, interestingly in 2024, just in March this year. It's incorporated trustees of MBA against Mr. Charles Ezeakbo. And from that report, I mean, it was a matter that came before the LPDC, where a lawyer had acted as commission agent to his client, had acted as manager of the property, had taken 10% commission, and in fact had collected rent from tenants and did not remit. About 16 million naira he had put into his own personal use. Talking about misappropriation of funds. And this is one of the vices that we see in practice. How does a lawyer deal with clients' funds? How do you deal with clients' property that has been entrusted to your care? If you're supposed to be a lawyer who has a position, a fiduciary relationship with your client, and a position of trust that has been given to you, how do you act in such a manner? The directive of the LPDC is that he should be suspended for 2 years. Now, this is just one of many vices that we see, when it comes to unethical conduct in our profession. So against this backdrop, I ask for you, Mr. Ojibe, to please address the expected ethical behaviors of legal practitioners and judicial officers in Nigeria. Are these behaviors peculiar to Nigeria? Is there something endemic about Nigerians that we cannot just adhere to ethical principles? I'm happy we heard from my learned silk, Oma Labi SCN. I'm so happy she opened her eyes. She said, in the UK, it is the same law that we're talking about now that they have been practicing for so long, and it's working. And standards are being upheld. And there's punishments. There's, it's the body, the authority there. They enforce the punishment where necessary. Mr. Ojibe, what is wrong in Nigeria? What is wrong with lawyers in Nigeria? Senior lawyers that have practiced for years, the new weeks that have just come, you people, your own is waiting for you. I understand that in court these days, when you go to court, you see a new week that was just called to back. You kept bags, seats, books. A senior lawyer comes to court and you don't even have where to sit. Ethics. Do you realize that this profession is supposed to be big on ethics? Respect. So please, I know you have so much, you've experienced a lot. Can you please tell us, are these behaviors peculiar to Nigeria? Are there lessons that can be learned from other jurisdictions, sir? Thank you very much.
Thank you very much, Sotoye. If you were not my friend, I would have told everybody that you were sent to settle. We're not supposed to talk about what we're doing, but I'm running an election and my team have told me, you talk too much. Try not to talk. But if there's a question for us, we'll answer it. So, first of all, I want to thank the SLP for today's session. Mrs. Boma Alabi, Senior Advocate of Nigeria, OM, Senior Advocate Tony Kukubo, and Sotoye. Fantastic work you guys are doing. I tell you, it's fantastic. The president of the NBA has been asking me, please, this shouldn't be repeated so that he doesn't remember. Let them wipe that one. To organize a training on ethics under the auspices of the ICN. He's even invited a Casey from Jamaica to help as part of that conversation.
I'm so sorry. He said, please can you put my...
Oh, sorry. He's even invited a Casey from Jamaica, a lady, and I had meetings with the lady. But I've always wondered to myself, can you really teach ethics to Nigerian lawyers as the way things are structured. And so I've been reluctant to have that training. That's why I commend you for taking this daring step. But it then takes me to the second question. Can we achieve anything if fundamentally we're not serious about that thing? Is it a talk shop? Are we just here to talk to each other? Is it an academic exercise? Does anybody here, especially the young lads, believe that we have ethics in the profession, in this our profession? Anybody? Do you believe? Are we regulated? I don't think so. I'll tell you about 3 experiences I had. The first is with a chap who's now senior advocate of Nigeria. So I come back to Nigeria after 10 years of practicing England. And my clients who had known me when I was a youth corporate in Nigeria said, Tobela is very tough. He needs to go and handle this. And I said, I don't have to go to Benin, to Chibibunevian's house to do this matter. I have a junior who can do this. He said, no, it's you we want, or my other partner, Tony. So eventually I said I'll go, and it was in Abuja. I took a flight with the senior lawyer. The man was talking to me. I thought he was a respected, he was a senior, he became a senior advocate the year after. In fact, matters relating to that case is still at the Court of Appeal. So I get into this man, Chief Ibunedian's house. I was supposed to present a check to Chief Ibunedian, a bank draft actually, in return for certain documents. So the man, I was observing things going on in the man's palace, so to speak, and I will see that the man does not take, he will take things but he doesn't give it to you. He will take from you, but he will hand things over to the next man to give you. So as we were talking about this transaction, I said, Chief, I expect that I will take the documents from you as I'm handing over the draft to you. He said, no, traditionally you can't. He will hand it over to my colleague. This is a senior colleague of mine. And I said to my colleague, I'm not going to hand over the bank drafts to Chief until I get the documents. And I said, no, go ahead. He's going to give it to me, and I'm going to give it to you. I've come back from England, and oral undertaking is like, is authority, is law. You take it to the bank. So I then said to him, okay, no problem. I hand over the draft. You take the you give me the document. Walking down, the man now said, you have to give me an undertaking for something. I said, what are you talking about? He said, you have to give me an undertaking before I give you documents. Hey, that was a terrible day for me. Because I'm thinking, a lawyer of my standing, how am I going to go back to my clients, tell them that I've released the draft, and I don't have a document? So I got upset and I started addressing the man. I said, you're late in the profession. And he was so adamant and so arrogant. So I thought better of it. I said, okay, fine. This is the scene, professional misconduct back, we will do it today. So I kept quiet. I said, sorry, sir. I left. He went to yesterday class and went there and all that. I went back to the man and I said, sorry, sir, you know, these things, you know, I don't have experience in Nigeria. Whilst he was looking away, telling them, you see what I'm saying? I just grabbed the file with the draft in it. I held it tight, and the man now went to Chief. This man that was speaking of people like Englishman, so you can do this type of thing. I said, I'm here to defend the interest of my client. Eventually, Chief said, okay, give me back the file. I gave him. I said, but on the condition that they will be returned to me. And that happened, but it was the first root shock I had about practice in Nigeria. Had two other instances. The other one, the commissioner of police actually, they said they were going to shoot. I said, who are you going to shoot at? Me? You know? A colleague had said to me, oh, this is what this matter is about, this is how we're going to deal with it. And by the time, a friend of mine, by the way, and my juniors have told me, oh, it is Mr. So and so person who was in the matter. So I said, okay, fine, big stuff. Got there, I spoke to him, he said, this is what it is. I sat down there, and then they were talking all sorts of nonsense. There were girls that colluded with the police. And I'm like, what is going on here? Lawyer to lawyer, no respect? I mean, there are plethora of these instances everywhere. And so I ask, are we ready? I'm on a journey today, contesting an election. And I see people asking me to pay their bar practicing fees. And I see people asking for all sorts of gratification to do what they ought to do what is right. And people are moving around. I called my folk on that. I said, all these things are not acceptable. Let's write about it. Let's make a declaration. It is nonsense. Until the day we decide ourselves to say that what is wrong, and that's what ethics is about. Right and wrong. It's not about all the things we write in the rules of. Look at the rules of professional conduct itself. You get how many CPD points to practice? Is it MBA itself? Does it have certificate? Does it give you a license? MBA that granted it, is it prepared? Is it equipped? Is it ready? Is it taking it seriously? There's so many things. You look at the RPC itself, you tell yourself, you're not serious. Somebody made a point here about this Kumu and the money laundering thing, that we want to be self-regulated in that particular area. And that was the biggest thing in the RPCDC. Why? Because we don't want anybody to look at our books. Is that how it is done in England? Is that how it's done every other place? People should come and look at our books. If we get it wrong, get it wrong. So there's a high level of selfishness. There's what I keep calling unenlightened self-interest. Chukwuka talked about 10 to 15 years, and I laugh. Do we even have a profession today? We must ask that question. We must be introspective about it. How we conduct ourselves. I went somewhere and I was trying to talk to people, just lawyers, talk to them. They were playing music and I said, there's a chance I'll be your president tomorrow. Put on the music so that they don't hear twerk when because that's what you hear. You're thinking, what did the man say? Hey, stupid man, president, how can you say this? You didn't ask him, why do you want to be my president? What are you going to do when you get there? How are you going to do it? Who are you going to do it? What is your track record? And the man suddenly becomes your president. How's that going to work? So, I think there's a fundamental problem with us. And it's about all of us without exception. We have come to accept what is not normal to be normal. And I'm happy that you are getting the fact that let's say Boma Alabiha talked about it. Because, you know, when my Lord Iwole was talking about removing regulation from the lawyers themselves, I was smiling because I'm a member of National Judicial Council, right? Nigerians believe in lobbying. My Lord, you talk about lawyers, eh? Me, they run away from judges, like I tell you. So when people pick up the phone, a court of appeal justice to say I should be at the Supreme Court, this is my case. That's I say, well, have you written a petition? It's a formal process now. You don't need to talk to them. It is our mentality, it's our mind test, it's a madness that is taking over the whole system. Before we came to, now going to England, before we came to the SRA, Senators Regulatory Authority, that now replaces us, it was a law society. But I used to have something I give every week. I will buy the Law Society Gazette. I'm looking. I'm counting the number of Nigerians that are going to be the road or suspended. Because we're always on the highest level. You talk about somebody taking somebody's money. Taking somebody's money. Put it in his pocket. No, move it from office account to client account, from client account, or don't move it within the proper time. So, it's so interesting that when I even have a conversation with colleagues in Nigeria about solicitors accounts, how it operates, how you move money from here to there, even accounting, you don't understand it. It's not as well as if it's part of what we do. They tell me accrual accounting, I say, what does that even mean in the context of what we're doing if we're really to practice law where you handle people's money? So, I think it's the seriousness. And, you know, my dad always told me that anything you do, you must remember who you are. The Nigerian legal profession does not know who it is. Be you the judiciary, be you the legal practitioner. We don't know who we are. The only profession in the world that controls exclusively an arm of government. My friend the governor said to me the other day that he didn't even realize that after swearing in a governor and the deputy, the next person attorney general. It's not about money. It's about how you carry yourself, knowing who you are. The way people will approach me in England, people who are much wealthier than myself, you're a commissioner of oaths automatically, you sign all documents because you're a solicitor. Why? Because you're regulated. Because there's a certain level of conduct expected of you because of who you are. So it's not that you went to law school and came out, went to the university. That's not what makes you a lawyer. It is your character first that must be put in issue. So, what did they do in England? People people are saying, oh, they moved on because they realized self. No, I think self-regulation was working, at least for the lawyers. But it wasn't working for the country. So the Prime Minister appointed Sir David Clementi, an accountant, the former deputy governor of the Central Bank of England, or Bank of England. Go and look at what these people are doing. Take away everything from them. Make sure that they are properly regulated. Why? Because even the integrity of the country is dependent on it. If a man has practiced successfully for 10 years as a lawyer, it should be very little question to be asked as to whether he should be elevated to the bench or not. Because you shall cut him out, by the way, on the road if you had any realistic system for checking out people's character. But here, character, ethics, we throw it to the bin. How many people actually look at that RPC? How many people look at it with seriousness? Even the MBA doesn't look at it with seriousness. Because if they did, I could challenge them. Where's my certificate this year? Where's my license? Who is monitoring my CPD hours? Right? I know there's a conflict between the RPC and the legal practitioners. I said, debate for another day. But if you have a profession where a brilliant document, the bill, the legal practitioner's bill, was put before the National Assembly, and Nigerian lawyers, body of benchers, and MBA, they are fighting over the things that don't matter. Then we must ask ourselves a big question. So first is that the legal practitioner in England himself takes himself, the profession, seriously. When I chaired conference of MBA in 2022, I made a commitment after there was a crisis. Two things there. First, I realized that the people had no confidence in those with authority, but there was a high level of rascality, and that the lawyers in Nigeria now lacked the unction themselves to even represent others. I didn't promise you a bag. You come to take your bag that will give you legitimate expectation because others have gotten it, and suddenly there are no bags. You start waiting. What would you tell your friends to do, your client to do, to shoot somebody? No, you lawyer, they didn't give you something, start fighting. What would you tell your client? You tell him to get a gun and shoot somebody. Because that means that you don't believe that there is a system of redress available. We went to the next conference. I told them, I said, this is endemic, let's look at it. You people are handling it. We went to the next conference, they were fighting over food. They were fighting over football match. Went to National Executive Council and they are talking about sanctioning on our budget. I said, people don't understand. We need to sanction all of ourselves. Because it will keep happening. When you're not happy, what a lawyer, you start fighting. So, the legal profession in England, number one, they take themselves seriously. They take the profession seriously. And what tells you how serious they take the profession is the system that leads up to you becoming a practitioner. You cannot become a practitioner. There are some rules now that consider other types of training before you qualify. But think about it. Somebody leaves law school. The only thing he knows about the RPC is what he has read in the papers. And then he goes and sets up his business. Why do they have PPA? Why do they have trading contracts? When I trained people in England, I saw how meek they were. They would listen to everything. They would shadow me. And very quickly, after 2 years, you see, and then they're under supervision for another 3 years. They're not mad people. They are thinking. So if we haven't even done that, right, and we put the CPD points, and I will always talk about this one, how can you say you're running a profession and you don't have a continuing professional development regime? You don't have it. It's a crisis. Tony, when he spoke about diversification and people moving to other things. No, I'm even talking about the one you're doing. The one that you're doing, you know it. People sit down in silos and do all sorts of nonsense. Have you ever been on a transaction with any foreign lawyer? It's only Nigerian lawyers that argue. Everybody else knows the position of the law in that country. So I think that our problems are fundamental. No, but it's true. I tell my colleagues, I say, you people really want or you go to get involved? They say yes. Then we argue for 2 hours, so you go with us in Lagos. Because our practice there, no, this, we don't see this. The only point you get to and the transaction stops when I was in England was commercial points. They get there, they say, oh, we have to take it back to the client. They have to take a commercial view on it. But the law is clear. The law society will have books, they have Bibles for everything. Everybody knows what is what. There's rigor, intellectual rigor, there's conversation. People, and that's what SLP is doing now. That's what SBL is doing now, which is fantastic. Let people come and share ideas. Nobody has a monopoly of knowledge. Somebody, you come to Nigeria and tell him, please, I need a president. He says, no, he doesn't have it, but he has it. Did you write it? Did you write it? So we have this crazy mentality, and that's why we are where we are. The entire gamut has to be re-examined. What we need is a root and branch. I was listening when they were talking about remuneration and young lawyers and the RPC. President of MBA, you stand up every day and not saying shame on you all that this is still happening. We must talk about it. So I'm happy that we're having this talk shop. But I will say to you, more importantly, anything we do, let us think about the outcomes that we want out of it. Let us be determined to stand by it. The incident I talked about, I was sitting with people, they were showing images of people. They said, these are the people who are suspected. And people were whispering. I said, do you know them? They said, I can't call them. You can't call them. And you want to move on. Every day they are asking us the remuneration order they are talking about. Who's going to enforce it? How are you going to enforce it? Lawyers are asking. The government has given you a law to protect your income. And we're asking, how do you enforce it? And it just my head. I said, what is the argument before the house? How to protect your own self from madness? No. So I think that, for me, we just have to be serious-minded. We have to ask ourselves serious questions. We have to start thinking in terms of fundamental change. If somebody gets it wrong, that guy next door has taken 2%, why you should take 5%? Report him. Start by reporting him. When you report him, if you have serious-minded people at the LPDC and they prosecute one person, all of us will carry the other guy and picture also. We read the client to say, client, I don't want to be like this man. Because that is the only thing that we know. But consequence management is something that we must pay attention to. Nigerians have lost the way in terms of reasoning. We must force them to do the right thing. Thank you very much.
Thank you very much. Thank you very much, Mr. Rejipe. I didn't expect less. You have extensively with the question that was put to you. And I like the fact that you also brought your experience from when you were practicing out there in the UK, which still reinforces what we had heard earlier, that it does work out there in other jurisdictions. And you have made the very germane point that it's something that has to do with us. So we need to look inwards and ask ourselves, is this what we really want? This is the profession that we have. Are we ready to do what it is, what it requires to preserve it so that it can endure? So that we'll still have a profession to practice in the next 10, 20, 30 years? It's a question that we need to really think about as legal practitioners. Thank you very much, Mr. Rejipe. Please put your hands together again for a very, very robust submission by Mr. Rejipe. And on that note, I just want to take it across board now. To Mr. Osu, just right by Mr. Rejipe. Please, I'd like you to amplify what he has said from your own view. What should we do? Maybe some suggestion that you would have, practical suggestion that you can give to us, on how we can return the legal profession back to its glory days of the past. Thank you very much, sir.
Thank you. This topic generally is something that I have spent a lot of time ruminating over, talking in different circles. But like I said, it is huge. I didn't even want us to cross over to the point where he talks about pupillage and why people are where they are. It has been a thing of concern to me from the past. How do we have a a day after call to bar, you can run off onto the street with a plaque on the wall and you say you set up an office. What do you really know? The sociologists have a reference to what they call tabula rasa. The fact that you studied law in university, graduated from law school, you don't know anything. I promise you. You know zero until you start practice. I remember when I started practice, I was as confused as a new dog. Everything looked weird. You came, but step by step. That's why it's called practice. And that's why I ask people, when I interview people, I ask, do you want to be a lawyer? And the person is confused. What does he mean? What does he mean? I'm a lawyer, I'm here, and I want to work. I'm saying, no. Do you want to practice law? Because they're two different things. If you do not understand that law is a vocation, law is not a job. It's not a job. If you're looking for a job, maybe you should go somewhere. But if you come to a law firm and you say you want to practice, it embodies so many things, all right? So the starting point for me is we need to go back if we have to cleanse the system. It's like talking about the educational system. We need to go back. When we have the numbers that we generate, I mean, I used to say to people, when we were younger, trying to study law, if you did not score 280, if you did not score 300, there's no likelihood that you will end up in the law department. If you're coming from A levels, if you did not score 10 or 11 points, which is maximum of 15, you must score 10 at this or 11. You're not entering into a law faculty. The first 2 years of the law faculty, when you start your core course, if you fail one the first time, you do a receipt. If you fail that receipt, you're getting out of the law faculty. So by the time you get to your final year, it's only those who could weather the storm that get to law school. And in law school, they're telling you law school has a slot. You're not taking more than 50 people from your faculty. So you knew that from year one. So your rigorous training starts from the first year of university. If you wanted to study law, it's not like I said, you're like a surgeon. You don't, law is, people's lives are in your hands. You can't just, it's not an all-comers affair. That's why they call it noble profession in the first place. All right? So the people who go through and get to law school and graduate are, quote and unquote, the best of the lot that started from the first year. So that's the starting point. Then you leave law school. We don't have any pupillage placing in place. We don't have it in place any longer. At the minimum, I expect you should work 3 years in a law firm, at the very minimum to 5. Like you said, 3 years, and then you're under supervision for another 2 before you say that, well, I'm at 5 years having practiced under people, and I'm good enough to be able to talk to a client myself, hold up. And we need to go, because if we don't do that, sometimes I'm in courtroom and I'm wondering, really. Someone said to me, a particular judge of the Federal High Court was a very haughty judge, right? I'd never been before the court before. And I appeared before her. And I said to the lady who told me that I should be careful because of it, I said, I don't understand. What's the problem? I said, the judge just always harasses people. She's very... And I sat through proceedings, and at some point, they called my matter, she stood it down. After making a submission, I sat down. 5 minutes later, she goes, Mr. Osu, did you hear what that lawyer said? I'm appearing before her for the first time. But one thing is clear to me. When you are in court, you need to be big on your courtesy. You need to be professional. You need to let the judge know that you came. And the only way a judge will know you came is that you're different. Okay, that's my first time before the court, and he said it's very haughty, very, she said asking, whenever somebody saw me say, Mr. Osu, did you hear that? Now, the reason, after proceedings, I said to my colleague, do you know the reason why people say this judge is haughty? It's because half the lawyers that appear before her irritate her. They come, they're not ready. They come, they're talking off point. They come, they're either lying. They come, they're not properly dressed. And she's consistently irritated by what she sees. So I said to my colleague, do you know the reason why she was like that? It's because I, a lawyer sitting in the bar, I was angry with no less than 10 lawyers. How much more the judge? She sees this every day. So as lawyers, decorum is important. Your ethical behavior needs to be at the top. If we're talking about pupillage, it's important that we try and see whether we're likely to go back there. Because if we do not, the kinds of quality of people that will consistently churn out is not going to make the cut. Like the winner was saying, if you sat on the transaction table at an international forum with lawyers from outside the country, if you have worked with them consistently, then you can understand how people behave generally, even in practice. So it's really important that we take those kinds of things on board. Discipline is important. The consequences of actions is important. If we do not have any consequences, then nothing happens. Then we also talk about the judiciary itself. Lord Denning has made it clear. He said there are two kinds of judges. The ones who are the bold ones and the ones with the timorous souls. If a judge is a judge of a timorous soul, will never be able to take a stance when it's important. It doesn't matter. I said something earlier. I said Justice Kensington requested that Chief Williams be brought to his court. It didn't matter that it was Chief Williams. Justice Kensington, anybody who knew him, was not a timorous soul. He was a bold judge. He bold to a fault. It didn't matter whose ox was going to be gored. So, Tobin also said, when people in authority understand who they are, the powers that they wield, then they'll be able to push forward to move things and make changes. If you do not understand the strength of your character as a judge, it's unlikely that you're going to make pronouncements that will make a difference. So that's for the side of judiciary. On the side of the lawyers, we must understand that judges and colleagues were all the same, but we must accord each other professional respect. If you have professional respect for your colleague, there are certain things you will not do. If you have professional respect for yourself and your profession, there are certain things you will also not do. But if you lack all of those completely, then you are no less than the person in the marketplace or some person in the garage. So until we understand who we are, the profession that we practice, the consequences of our actions, we will not do certain things, and it's unlikely that we're going to move forward. So on that note, I'd like to leave that there, because there's so much we can talk about. Someone has said that this is something that should take it to the AGC, because the topic is big, it's huge. We can't complete that in a short time. So I'll yield the microphone now to my colleagues.
Thank you very much, Mr. Thank you. You have covered the field. I'm so excited. The panelists here are well-grounded, and in a very, I would say, so you took us through, what you think should be done for the lawyers. You're looking inwards, consideration for pupillage. You went to the judiciary as well, and I'm happy that you made reference to the statement of a very well-respected judge, Lodeni, what he said about, two types of judges. I find that very powerful, the bold judge and the judge with the timorous soul. And on that note, I'd like to say thank you very much, Mr. Su, for that, and to also say that thankfully, from what we heard earlier from my Lord Honorable Justice Lemi Ango, she has demonstrated that she's not a judge with a timorous soul. She is indeed a bold judge. And on that note, my Lord, I just want you to say one word, 1 minute, because we need to ask, throw the floor open for questions. Just 1 minute, what you think to return the profession back to its glory days. Thank you so much, ma'am.
I think Mr. Suas he's captured it so well. The place of training, retraining, and just asking ourselves questions cannot be overemphasized. So you see a clear difference between lawyers that underwent village for a period of 3 to 5 years, and that's what I recommend. You see a clear difference with the one that come out today and tomorrow they are sole practitioners. It can never be the same. Because as I said at the beginning, everything is confusing. So how do you know what to do and who guides you? And the difference is there. The difference is there. I underwent privilege with Professor Dita for 5 years. 5 years. And after that, I was able to fly. When I mean fly, anywhere, any transaction, any case, anything that came across my way. So this is one area that I am also big on, very big on. In addition to every other thing said today with the conversations from all of the speakers. Thank you.
Thank you very much. And on that note, I'd like to give a few minutes because we're going to be wrapping up, very soon. Leonard Silk, Mr. Kukubo has been giving me the eye, and I will be wrapping up very soon. Leonard Silk. So please, I'm now throwing this open to my audience here for questions. Anyone has a question? One or two, or contributions? Okay, I will yield the mic to my chair, the chairperson of the MBA Lagos branch.
Good afternoon, everyone. And mine is, well, I'd like to first thank one of our shining lights for your presentation. Thank you very much for the work you're doing. Mine is more of a clarion call to all of us as lawyers. I try to use myself as an example because, yes, I also underwent overlay the of Palati for almost 2 years. Quite clear that one. But the problem today is one of lack of respect in the profession. And forgive me if I'm deviating from the topic of discussion, but I find it sad that we've lost respect. The profession is one where respect was critical. When juniors would respect seniors, when seniors would respect juniors. But today, it's all gone. And so, mine is a clarion call to all the leaders in the room. Let's find a way to bring back respect to the group. That's my charge to all of us here. Thank you very much.
Let it not be said that I took part in this event and you make one or two comments. And I really do want to thank Mr. Moderator and the distinguished panelists. And everything said speaks to the issues that we all have to contend with. So what's my personal experience? So again, like the president of the bar, the branch, MBA branch, and they just said, also have privilege. What I call privilege? With Chief Esther Molakun, then on 209 Goshere Road, where I started my practice. Interesting, fantastic 4 years thereabouts with it before I joined my current firm. But it taught me a lot. Someone made a comment here about younger counsel, and I dare say sometimes older ones coming to court simply because they have 2 or 3 matters in different courts, leaving either their file or their bag, as if those were the things that were called to the bar on the table. And you will be shocked as to how upset they can be when they come and they see that you moved that non-living thing to one corner. And I remember Chief telling me in those days that you are at war when you are in court. Don't leave your file on the table unattended. Crazy things happen. Crazy things happen. And in law school in Lagos in those days, I remember when leaving the amphitheater, a good friend of mine is also a lawyer in Port Harcourt, and I would always joke, put your hands in your pocket. Don't think because we are lawyers that your biros and things cannot suddenly find themselves elsewhere. So these are things that we should take seriously. Lord, I would like to speak to some of the issues you talked about, particularly one about emotion. Counsel arguing amongst themselves. And I came across something, and it was shared a couple of weeks ago on WhatsApp, and I think it resonates with some of the things we're discussing here today. Somewhere in Canada, a judge had cause to deliver a ruling, and in the course of that, he made some very interesting comments that virtually is situated within the confines of the courts in Nigeria. And I'll just paraphrase some of the things he said. He said during the application hearing, counsel to the applicant somehow decided that it was appropriate during opposing counsel submission to express themselves by way of, amongst other things, eye rolling. It's important we know what he's saying, eye rolling. And I'm sure some of our colleagues will know what I'm talking about. Head shaking, grunting, snickering, quaffing, and loud mutterings. This behavior culminated in one of them leaning back in his chair, throwing both hands in the air, and laughing in a gleeful moment of triumph during a particularly engaging exchange between opposing counsel and the bench. Apparently, applicant's counsel felt that he had scored some major points during my questioning of the respondent's counsel and wanted to ensure that everyone else was aware of this victory. Then listen to what the judge said. I addressed this misconduct, that's what he calls it, at the applicable time during the hearing, and on my insistence, the once exalted counsel apologized to his colleague. However, the ignoble display continued, albeit mutually and intermittently, for the rest of the hearing. It takes you back to their lordships that will query you when you show unnecessary emotions while doing a simple matter. Unfortunately, behavior engaged in by applicant counsel is neither a new nor rare phenomenon. Too often, counsel seem to believe that enthusiastically attempting to disrupt and or demean opposing counsel during the latter's oral submission is one of the hallmarks of an effective advocate. It is not. Too often, counsel seem to believe that rolling eyes, dancing eyebrows, and other mannerisms, whilst opposing counsel is making submissions to the court, constitute proper critique or response to no submission. They are not. Counsel submission to the court are to be made in only two ways: written and oral argument. No proper submissions are made by way of emanations from counsels, be they oral from counsel, be they oral, non-verbal, audible, or inaudible. When another justice participant is speaking, indeed during a court hearing, there should be nothing from counsel but complete oral and non-verbal silence while someone else has the floor. Anything other than such complete silence is not only distracting to the court, but is also profoundly disruptive, disrespectful, and demeaning to everyone in that courtroom. I fully acknowledge that in the heat of battle, human emotions run high and can sometimes get the better of even the most seasoned advocate. However, I'm unable to countenance any circumstance under which this type of sophomoric behavior, too often demonstrated by counsel, could possibly be excused, let alone acceptable. It is not only discourteous and disruptive, it is also antithetical to the peaceful and orderly resolution of disputes and undermines procedural and substantive fairness. He now cites a case. Now listen, the type of misconduct demonstrated by applicant's counsel in the case at bar significantly delays the timely and effective administration of justice, exerts an unnecessary and unacceptable additional cost on litigants, and erodes the public respect for the legal profession and, more importantly, for the rule of law. The parties' counsel, other justice participants, the public, and the administration of justice deserve far better than what too many counsels seem to have to offer. Whether the culprit is a lack of proper mentoring, which I think is what most of the panelists have talked about today, and overconsumption of courtroom television shows. For those of you who watch Suits and all those things, I think that that's the way he can behave in court. Extended periods of time without in-person human interaction. Now that personally I think is an insult, right? Extended periods of time without in-person human interaction, or something else entirely. A fundamental shift in mindset is required to stem this tide. Finally, it has long been a tradition and requirement of etiquette in our courts that counsel refer to their counterpart as their friend. While most counsel uses appellation painfully, few appear to understand that the fundamental intention underlying its use is to remind counsel of their duty to treat opposing counsel with professionalism, courtesy, respect, and civility. I suspect Todena's experience in Benin speaks to this. All counsel will be well advised to always keep this top of mind, lest the already threadbare state of professionalism and civility between them deteriorate into irremediable. I think these are things that resonates with us. And I think it's something that we should take home. Mentorship. Being aware that it wasn't your files or bags that were called to the bar. Being aware that you owe a lot of duty to the court and your colleagues also. I mean, professional at all times. I need to not say more. On that note, may we thank very esteemed panel. Please, the ladder one round of applause. Because you have to understand that the Lord, the Honorable Yosef was once somewhere. And I will quote her, if you know, you know. So it's important, you don't know. It's important you give a very warm round of applause to the very good efforts deployed by the panelists. Thank you. Now, I'm part of Kemi, I think. Yes. Kemi, because yes, so that we can do the usual. Meanwhile, may we call on the moderator and the panelists for a group photograph, after which we'll present some gifts. colleagues, thank you so very much for your time. This brings today's event to an end. Thank you so very much. Very nice. Thank you.